Seated. Welcome again, everyone. We're back here for the second day of oral arguments on the Holtec matter, Holtec International's application to construct and operate an interim nuclear waste facility in Lee County, New Mexico. I think the way we'll proceed this morning is first with Fasken, and then I believe if the representative of the city of Carlsbad is here, we'll give you a few minutes to say what you would like to say, and then we will turn to Holtec, which will probably take quite a bit more time, and finally the NRC staff. Any questions about how we're proceeding today that we haven't addressed? Everybody's prepared to go forward? Sounds good. Somebody, yes, and a reminder again to turn off or rather silence your cell phones will help a lot. Okay, well let's begin then with the representative of Fasken, Mr. I.
And may it please the panel. My name is Robert I. I represent Fasken and Permian Basin land royalty owners. At a bare minimum, any decision concerning the establishment of a consolidated interim storage facility that would have the greatest concentration of radiation between here and the sun should be done in conformance with applicable law. The application before you now does not meet this minimum test. Including any Department of Energy involvement in this proposal violates the Nuclear Waste Policy Act. When Congress passed the NWPA, it recognized the real possibility that establishing a CISF without a deep geologic repository would effectively relieve the pressure off the imperative to establish a deep geologic repository. Why did Congress and the NWPA require the repository be available and operational before allowing a CISF? Congress well recognized that putting a CISF into operation simply allowed a further delay in establishing a deep repository, kicking the can down the road farther. And yet, in 2019, this seems to be in doubt about whether, or there seems to be a doubt about whether this unambiguous intent of Congress that clearly is manifested in the text of the NWPA is being met by the application presented by Holtec. This doubt raises all of the familiar problems with reaching a final disposition of spent nuclear fuel in a deep geologic repository. As plans are made to store 173,000 metric tons of spent nuclear fuel in southeast New Mexico, durations of time for the use of this facility exceed 100 years. What is the public to make of this? Hearing these durations with no prospect of a deep geologic repository raises the issue of adherence to the rule specified in the NWPA. The applicant and staff have been silent about this attempted end run around the NWPA. This silence, coupled with the idea that the proposed CISF will be in operation for over 100 years, leads to the conclusion that a deep geologic repository is just so much pie in the sky. The authors of the NWPA would be troubled and perplexed by this circumstance. They would be, I think, very disagreeable about how their careful sequencing and balancing in the NWPA has been disregarded in the Holtec application. This application puts the cart before the horse. In doing so, the NWPA is violated. And that is why Fasken and PBLRO took the steps it did to file a motion to dismiss the application. And I'm sure that there will be, I sense that there may be some questions about that later, so I will turn and make a few brief statements about standing. Fasken and PBLRO have standing. First, as discussed in the declaration of Tommy Taylor from Fasken, Fasken has mineral interests 2 miles from the Holtec site. These are mineral interests that represent a substantial business investment, and they want to protect those. This close proximity puts Fasken well within the zone of the 14 to 17 miles that we've discussed, we've heard discussed prior, that has been recognized as a proximate distance to justify standing in a CISF context. Fasken's interests and their interests of their counterparts in PBLRO are jeopardized by the Holtec proposal for its CISF. Not only are the economic interests related to the mineral rights at stake, but as Mr. Taylor points out in his declaration, there are concerns about the health and safety of people in the area who are exposed to this radiation, and that indeed that might force Fasken to incur further costs to accommodate a CISF. Fasken and other members of PBLRO work and live in that area. And Fasken, for example, has to dispatch workers out to that area to tend to its interests. Fasken recognizes that things like medical costs, lost productivity, and long-term viability of their business interests are directly at stake with the CISF that's proposed in this matter. You heard yesterday about how the oil and gas industry is so robust in the Permian Basin area that they can't find enough workers to fill all the available positions. This is a sign of business activity that's not only enviable, but it helps sustain the economy of this area. The thousands of jobs that Fasken and its PBLRO counterparts offer are at stake, which ripples through the way of life of this entire area. PBLRO's purpose, as stated in our papers, is to protect those interests from the hazards represented by the Holtec CISF. Accordingly, PBLRO has representative standing. With that, I will do my best to answer any questions that you have.
Thank you, Mr. Rock. I think we put in our January 10 order 2 questions that really are directed at you, questions 3 and 4. Let's assume that your clients have standing. Hypothetically, let's assume the board concluded that. The issue that we see is, and it's complicated by the procedural posture here. Let me go back a little bit. You, on behalf of your clients, filed a motion to dismiss, as I recall, not a petition with contentions. And Beyond Nuclear filed both a motion to dismiss and, as protective matter, a petition with one contention, fundamentally the same issue as the motion to dismiss. Your your motion was directed at the commission. Through the secretary, the commission has, in effect, said that we should treat your motion as a petition with a contention. The problem that I see, I think the board has concerns about, is that commission case law is pretty clear that a petitioner may adopt the contention of another petitioner, but only if the petitioner who wants to do the adopting has a contention of its own. And in this instance, your motion essentially adopts the arguments presented by Beyond Nuclear's motion. And so therefore, aren't we kind of stuck with the rule that you have not submitted a contention of your own?
As we explained in our response, that I think addressed this at least in part, it was never our intention to present a contention. Right? I mean, to us, this is a counterpart, a parallel. It's analogous to a Federal Rules of Civil Procedure 12B motion. It says, in effect, that the commission lacks jurisdiction. That's a classic 12B motion. If we concede that a petition, or that a contention is necessary, we effectively have abandoned this idea that somehow, that you don't have jurisdiction. We implicitly say, with this contention, you have jurisdiction to decide this case. And indeed, it goes to the heart of our arguments that the issue of the NWPA's involvement in this case, although absent from the discussion from the applicant and staff, is one that is extant and it's existential in this case. A jurisdictional matter ought to be handled properly in the context of a motion to dismiss. I grant you that it falls outside the strict formalities of contention practice, but so does the omission of discussions of the NWPA. So how do we respond to that? Do we essentially accede to the idea that the commission has jurisdiction, submit a contention, and let it play out, only then to be confronted by a judge on appeal who says, it appears to us that, in fact, you recognize the NRC's jurisdiction over this? So we were caught, one of the other counsel put it well yesterday, caught between the proverbial rock and hard place. The context of this is unusual. It's unusual for the panel, for the commission, for the participants. And we couldn't find another instance. We looked, and we couldn't find another instance where the secretary had actually taken the step that was taken here, where they take a pleading, they send it back to the panel, and they say, treat it in this way. So that lack of precedent puts us all into unknown territory, I suppose, or uncharted territory to a certain extent. But we have to remember that the essential piece of this is to ask, has the applicant conformed to the Nuclear Waste Policy Act? Irrespective of the procedural means to get to that question, whether it's through a contention, whether it's through a motion to dismiss, the issue remains the same. So we certainly were not intentionally setting out to make this thing a procedural morass. We really were not. On the other hand, we had to make some judgment calls about how to proceed, and this seemed like a logical way to proceed, to have it run more or less like a 12B motion would in civil practice in court.
Yeah. Beyond Nuclear's response to the Secretary's ruling was also to go directly to a federal court of appeals. In Beyond Nuclear's case, the United States the Court of Appeals for the District of Columbia Circuit. Have you sought relief in the Court of Appeals on an interlocutory basis? Or have you sought any relief in the Court of Appeals?
I'm sorry, I didn't hear the last part of your question.
Have you sought to review the SECI's order in the Court of Appeals?
We have not yet.
Okay. Do you still have time to do that?
We have not. We're here. And again, this is a procedural scenario that only Franz Kafka could really completely appreciate. And it does leave us all a little uncertain about what steps ought to be taken. So, partly respecting the fact that the Secretary sent our motion back to the panel and asked that it be characterized and considered as a contention, in respect of that, and to have an opportunity to present our arguments to you we hope in a persuasive fashion, we decided to pursue this route at this point. And again, it is unusual. We're hoping that at some point procedurally we get clarification, but I'm not actually counting on that. So
okay, I think if I understand your argument correctly, I think I do better as a result of your comments right now. If you had filed a petition with one contention that adopted somebody else's contention, it is pretty clear, I think, under commission precedent that you are out, that you can't just adopt somebody else's contention. You have to have one of your own. But what you're saying is, I think, is that this is a very unusual, indeed unique situation where that is the board, has been told to treat this as a contention, but this is unprecedented, and perhaps the commission's ruling on that issue was intended to apply to people who had intentionally filed contentions, but not to those who were told you may have filed a motion, but it is a contention, it's going to be treated as a contention. So we should consider it in that light.
Perhaps. I mean, but there are other ways to interpret what was done as well. So again, we're working in sort of an unclarified context.
Yeah, but I mean, what you're saying, I think, is that we should consider whether the commission precedent applies in this unique situation. The commission precedent in the normal situation is, I think, pretty clear. But you are urging that we take a hard look at whether the commission precedent, which would effectively throw you out, your client out, whether the commission would really have intended it for it to apply in this unique situation.
That is correct, Your Honor. And one other minor, I think relatively minor point here. I'm not sure that I really agree that we have adopted the contention of Beyond Nuclear. We adopted their legal argument because it happened to support our client's interests. The contentions have certainly the same intention, rely upon the same legal reasoning, but they're different parties with different interests. But I don't really think that point is controlling. I don't think it's dispositive. I think what's dispositive is what you just articulated, Judge, in terms of trying to figure out what to do in this unusual context where you have neither fish nor fowl. And yes, that is unusual. The NRC's general practice for resolving these kinds of disputes is through contentions. So all of a sudden now you get a party who throws a curveball and raises a motion to dismiss. It's not as if motions to dismiss are unusual or unheard of in various forms of practice. It's just that in this context it's outside of what is normally expected.
Okay. Thank you. Judge Arnold, did you have questions? Judge Dukouros? No question. Thank you.
Thank you.
Well, let's deal with a few brief comments from the city of Carlsbad. Is that Mr. Shirley? Welcome, Mr. Shirley.
Thank you, Your Honor. I appreciate the opportunity to speak to you today, and I apologize, my voice is a little rough today, so we're going to get through this, though. As you know, my name is Jason Shirley. I serve on the City Council in Carlsbad, and I'm the designated representative to the ELEA Energy Alliance that is working with Holtec on this project. Carlsbad has an official population of 27,000 people, but is much larger in recent years due to the expansion of the oil and gas in the region. Excuse me. Additionally, Carlsbad is approximately 35 miles away from the proposed Holtec high-store consolidated interim storage facility. Carlsbad has been keenly interested in the development of the Holtec site since the 2013 report from the President's Blue Ribbon Commission recommendation that a consolidated interim storage facility be established. The CISF will have a real impact on our community, and we expect that it'll bring the following benefits to Carlsbad, that it'll create several hundred jobs for our citizens, that those jobs will come with high salaries and raise local wage averages. It'll generate significant tax revenue for the city of Carlsbad, improving our infrastructure and further diversifying our economy. It will not only benefit our region, but also provide a service for our nation in safely storing spent nuclear fuel. We're familiar with living near a site for nuclear waste disposal, as we are located 25 miles from the existing waste isolation pilot plant facility that's ran by the Department of Energy, which employs some 1,200 people and has a $400 million annual budget that benefits the region very greatly. Our constituents support the Holtec CISF. We know that we are a nuclear-savvy community with many years of experience in the field. We've seen success, we follow the science, and we have a culture of safety in Carlsbad. We also are here today to show our support for the Holtec CISF. It's welcome in our community. We look forward to the jobs, the revenue, the diversification, and the other benefits that it will create. Thank you so much for your time today.
Thank you, Mr. Shirley.
Yes, sir.
And I'd just like to confirm, I believe we heard yesterday that the city of Hobbs will not be participating orally. Again, all of the petitions by local governments stand unopposed at this point, so there's certainly no need to say anything today. We will next move to Holtec, and just two comments to start. I don't know, Mr. Silberg, will you be speaking? The opening statement. I don't know if you need extra time. We recognize it's 5:30 to 1 at this point, perhaps, is a way to characterize it. So our clocks might run a little slow on the 10 minutes if you need more time, but you may conclude that you really just want to answer the questions. Either, Mr. Silberg, you or one of your colleagues probably should address at the outset, either as part of your opening or right after it, the issue we asked for some comments on yesterday. And what that related to was NAC's argument that if they are not in this proceeding to address the environmental report issues now, they will not have the same opportunity at a later time if there's an amendment, hypothetically, that would permit the NAC canisters to be placed in the Holtec casks. So either you, Mr. Silberg, could address that in addition to your general opening, or one of your colleagues would appreciate that. Thank you.
Good morning, Mr. Chairman and members of the board. Holtec International appreciates this opportunity to appear before you as an important step forward towards the licensing of the Holtec high-store consolidated interim storage facility. We believe that this is an extremely important facility for this nation. Holtec is pleased to be able to sponsor it. We're disappointed that we need it because the Nuclear Waste Policy Act provided that the Department of Energy was supposed to start accepting spent nuclear fuel from the nuclear industry starting January 31, 1998, a day some of us will say will live in infamy. Because they have not met that obligation, and because we do not have a permanent repository, facilities like this are necessary for a variety of reasons. There are stranded spent fuel storage installations around the country. There will be more of them as time moves on, because plants are shut down, the plants are decommissioned, and everything but the spent fuel is off the site. Facilities like the Holtec facility will enable those sites to be finally returned to other productive uses. Both the utilities that own those sites and the jurisdictions in which those sites are located would desperately like that spent fuel to be stored safely, environmentally secure at another location. This location is also a much more secure location than where many of the interim spent fuel storage sites are now located. Some of those are very near major metropolitan areas. There are many of them scattered around the country. It is safe at those locations. We believe it is safe. The Commission has found that it is safe. But it would be better if it were in a more remote location, far away from metropolitan areas. In any event, with those introductory remarks, let me first introduce the Holtec team. Our attorneys from Phillipsburg Law Firm in Washington, myself, Jay Silberg, Tim Walsh, and Ann Leidig, my associates. The Holtec management, project, and technical personnel here today: Joy Russell, who is the Senior Vice President and a member of Holtec's Executive Committee; Ed Mayer, who is our project director for the High Store facility; and Kim Manzione, who is the licensing manager. Let me give you a little bit of background about Holtec. The company was formed in the mid-1980s. Today it designs, engineers, licenses, manufactures, and deploys its technology and services around the world. And while nuclear is the focus of Holtec, Holtec also provides technology for solar, geothermal, and fossil power industries. Holtec's early focus was on heat exchanger technology, and today over 120 power plants on 4 continents use these Holtec components. In 1992, Holtec launched its technology for dry storage of spent nuclear fuel. Among the first of that technology were the first licensed multi-purpose canister, storage and transportation, the first dual-purpose metal cask, the first transport cask licensed for high burnup and MOX mixed oxide fuel, and the first double-wall canister for spent fuel storage. The Nuclear Regulatory Commission has issued certificates of compliance under 10 CFR Part 72 for 4 different Holtec dry storage technologies. Its dry storage systems were first installed in 2000, and today over 1,200 Holtec systems are in service, storing more than 62,000 spent fuel assemblies in 65 nuclear sites in the U.S. and 51 nuclear sites abroad. In addition to dry storage, Holtec is a leader in wet storage technology and is currently developing the design for a small modular nuclear reactor. And more recently, Holtec has become involved in the nuclear plant decommissioning and has agreements with 2 utilities to own and decommission their reactors, including assuming the ownership of spent fuel. The NRC staff is now reviewing the license transfer applications for those facilities. Once those transactions close, Holtec will, in essence, become a nuclear utility owning spent fuel currently on dry storage and in pool storage. Holtec manufactures all of its own equipment and has 3 U.S. manufacturing facilities with more than 1,400,000 square feet of manufacturing space. In addition to manufacturing dry storage systems, Holtec has also constructed spent fuel storage facilities and provides for moving spent fuel from pools to pads. A little bit about the project. I think as you've heard from representatives of the jurisdictions that will host the facility and that we work with closely, Holtec has a well of local support for these facilities and a well of support around the state. In 2015, the governor of New Mexico wrote to the Secretary of Energy suggesting the consideration of an interim storage site in southeastern New Mexico. In 2016, the House and Senate of the New Mexico legislature both issued memorials in support of a CISF facility. In April 2016, the ELEA Energy Alliance that you've heard John Heaton speak about yesterday, and the cities of Carlsbad and Hobbs, and Holtec entered into a memorandum of agreement for the high-store facility. And in July of 2016, the New Mexico Board of Finance approved an option agreement for the sale of the high-store site to Holtec. As you've heard, the site is in Lee County, about 35 miles from Hobbs, and about 35 miles east of Carlsbad. It's a little bit over 1,000 acres. The area is home to other nuclear projects, as you've heard, the Uranco Uranium Enrichment Facility in Lee County and the DOE WIP facility in Eddy County. The project itself will use Holtec canisters, the initial phase, with NRC certificates of compliance that are loaded and welded shut at utilities, transported to the site unopened, and placed in subsurface vertical modules at the site. The canisters are not opened after being welded shut at the utility site. The initial phase will be, for which we've applied, is 8,680 metric tons, or 500 casks, and the initial phase is limited to Holtec casks and canisters. There may be subsequent phases. The site is capable of storing 100,000 metric tons of uranium in 10,000 canisters, so Holtec is not asking for a license beyond phase one. But because expansion is possible, the environmental report evaluates the environmental impacts for all phases. And I would notice there has been a lot of discussion that the capacity is 173,000 metric tons of uranium. That is a number that is not correct. The capacity as defined by Holtec is 100,000 metric tons. Studies at the site started in 2006 as part of the Global Nuclear Energy Partnership, a $250 million DOE project to develop advanced nuclear technologies. HISTOR is based on licensed technology which is currently installed and in operation. The HISTOR UMAX, the underground storage, certificate of compliance was issued in 2015 and is currently at use at 2 U.S. nuclear plants. I want to be very clear because a lot of the discussion centers around the role of DOE. This project is not dependent on contracts with DOE and is not dependent on DOE ownership of the spent fuel, and I'm happy to respond to the questions you may have on that. But the short answer is, if DOE is not entitled to hold title to commercial fuel, DOE won't be involved. The NRC review, the application was filed in March of 2017. It was accepted for NRC review in March 2018. Holtec has received 4 requests for additional information from the NRC staff. That process is well underway. As to the petitions to intervene, we have carefully examined each one and have addressed in our submittals whether each has met the Commission's requirements for standing and contention admissibility. and we believe they have failed to meet those requirements. Our answers to the petition set forth our position in detail and explain why the petitions do not meet the NRC standards. In the interest of time, we will not try to summarize our positions, for they are well set forth in our briefs, but we're very pleased to answer questions that the board may have. We thank the board for being here. We look forward to answering your questions, and we look forward to dealing with you through the completion of this licensing facility. I'd like also to ask the board's permission if we could sit at the front row. We'll be passing the microphone, if we could have the microphone back and forth between Tim and Ann and myself.
Yeah, I think that will work nicely.
Thank you very much.
Our space here was not what we originally intended, and we're doing the best we can.
We understand.
Thank you.
Let me first address the question you raised about the NAC issue. We believe it's incorrect that if they're not in this proceeding, they will lack the opportunity to address the environmental report. Right now, the application does not permit the storage of NAC casks or non-Holtec casks at this facility. We accept and are very, very clear that in order for other vendors' casks to be stored at the site, we would need to amend the license and would need to amend the certificate of compliance for the UMAC system. Because right now that is only licensed for Holtec casks. It may well, we may well file those applications. The casks, the underground facility, are large enough to accommodate casks of any canisters of any manufacturer. That's why we call it universal. We recognize that NRC will have questions. We recognize that the licenses and the certificate of compliance may need to be amended. At those times, we will have to, as part of the application, determine whether there are any changes needed to the environmental documents that have already been submitted. There will be an environmental statement in each application. That statement may be, no change is required. If a change is required, our application will include that. If the NRC staff disagrees with our conclusion, if that is our conclusion, that no changes to the environmental analysis are needed, the NRC can ask us additional questions or can provide that information on their own. We will have to deal with it. If NAC believes that our conclusion, if that is our conclusion, that no changes to the environmental report are needed, they can challenge that conclusion in the appropriate form, which may be a license amendment, may be an amendment to the COC. They will have rights to participate. They will not be shut out. Right now, their interests are not affected because they're not in the application. We don't say in the environmental report that any NAC casks will be stored at the site. We've tried to bound the environmental impacts by saying, here are the impacts for a fully developed site. If the site is less than fully developed, if we only build 5 phases instead of 10 phases, we have bounded the environmental impacts. If we reach the full capacity of the site, we will have fully addressed the environmental impacts. But in no case are we shutting out NAC if they have issues with their particular casks. But what we have looked at here is the capacity of the site, whether it's 100,000 tons in Holtec casks or 100,000 tons in Walmart casks, whoever casks those are, we have evaluated. There's nothing unique about NAC. Their interests are not affected. We're not saying anything good, bad, or indifferent about their technology. So our answer is we don't think they need to be in this proceeding to protect their interests. We don't believe they have demonstrated that they have standing, and we don't believe they have demonstrated an admissible contention.
Thank you, Mr. Silver.
And at this time, if I could regain my seat and we'll go through.
You may. Could be a long time at the podium otherwise. I probably have fewer questions than my technical colleagues, so let me begin again. First, Mr. Silberg, you have every right not to respond on these points. There were last week motions to file new or amended contentions that seem to be pretty closely related to Beyond Nuclear Contention 1 and Beyond Nuclear's only contention and Sierra Club Contention 1. And are you prepared to discuss those at all now, or do you want to wait? You have until, I think, mid-February, February 11th, something like that, to respond to those.
I can certainly discuss.
Okay.
I can certainly do.
That works.
Yeah. I've missed my career as a rock singer where you get to them. I can certainly discuss them, and I think I would like to put in perspective some of the statements that have been made, because I think for those who may not be familiar with the project, there's a lot of misinformation that we've heard.
Excuse me. Yeah, I mean, if you're prepared to address them, then to some extent, you have time to respond in writing, and then there will be a reply. But I must say, I was somewhat struck myself by what appears to be a Holtec document that was issued this month. And we hear from you that if DOE can't be involved, they won't be involved. But the Holtec document, I'm not quoting it, but loosely says, and of course this Lee County project will have to await action either by the Congress or by DOE, and that was confusing to me.
Let me read you the sentence, and I would say that this is one sentence out of a 6 or 7 page document. The sentence has been totally taken out of context by the interveners. What the sentence says is, quote, while we endeavor to create a national monitored retrievable storage location for aggregating used nuclear fuel at reactor sites across the United States into one, high-store CISF, close paren, to maximize safety and security. Its deployment will ultimately depend on the DOE and the U.S. Congress. And it's that last phrase that seems to have gathered everybody's attention. Honestly, I think the sentence has been totally misconstrued by the petitioners. The phrase in question, its deployment will ultimately depend on the DOE and the U.S. Congress, does not say that we need DOE approval to go ahead. It does not say we need DOE to hold title to spent fuel. It does not say we need DOE to take over any aspect of this project. What it says is that if DOE and the Congress make decisions, particularly with spent fuel storage and permanent storage, that will have an impact on this project, and its deployment will depend on that. If, for instance, Congress and DOE decide to go ahead with Yucca Mountain, we pray that would happen. And it's ironic that people who criticize this facility as perhaps reducing the incentive for permanent disposal are among those who have fought toughest to keep us from developing Yucca Mountain. Putting that aside, if Congress were to take steps to put in place permanent disposal or federal interim storage on a schedule that made the CISF, the Holtec High Store project, unnecessary, obviously that would have an impact on the Holtec High Store project. So its deployment would ultimately depend on what DOE and Congress does. If we build phases 1, 2, 3, 4, 5, and Yucca Mountain becomes available, we won't build phases 6, 7, 8, 9, and 10. So the obvious connection between the state of the DOE nuclear waste program and interim storage is clear to everybody. Because if we had interim storage in operation today, we wouldn't be here. We would be most pleased to be sending fuel directly to Yucca Mountain. Unfortunately, we're not in that position. The utilities, after having contributed $35 billion to the federal treasury to pay for Yucca Mountain, find that their money has dissipated. $7 billion has been spent on Yucca Mountain, and there are people in Congress and in the outside community who would like that money to be thrown away, for Yucca Mountain to disappear forever. If Yucca Mountain proceeds on a schedule which makes this facility unnecessary in whole or in part, if some other permanent disposal facility were developed on a schedule which makes this facility not usable in whole or in part, that would have an effect on the deployment of this facility. That's what that statement means. Nothing more, nothing less. The environmental report has been amended. Rev 3, which was filed with the NRC in November, which is available, publicly available, has made clear that the few references in the report where it appeared that DOE would hold title to the fuel or would be responsible for the fuel that would come to Holtec, those references have been clarified to make sure that it is either the utilities or DOE. And the reason DOE is in there is DOE may have the ability to take title. They don't now. We agree with that. For commercial fuel that they don't already have, unless it's through an R&D program, because DOE has a few assemblies from commercial reactors that it took for R&D that are currently at Idaho National Labs. But if Congress passes legislation that allows DOE to take title, if Congress passes legislation which authorizes direct funding for this project, then sure, DOE would have a role. That isn't the situation now. We're not depending on it. We don't assume it. The statement that we heard yesterday that having option 1 and option 2 means that both options are illegal just makes no sense at all. Severability clauses exist throughout private and contracts and public statutes. There's no indication that putting DOE as a possible participant in this would make illegal private participation in the absence of DOE ability. The environmental report where these statements appear is to describe what are the environmental impacts. If you look at it in that context, we don't need to address who owns the fuel at all, because whether it's DOE holds title or the utilities hold title or Holtec holds title, the environmental impacts are going to be identical. So the statements in the environmental report are useful for background information, but in terms of environmental impacts, and that is what the environmental report is there to do, those statements have no bearing and don't provide a basis for contention in this proceeding.
I just want to be sure I heard you correctly, Mr. Silver. You said that today, are you conceding that as of today, DOE cannot take title to spent nuclear fuel, that it doesn't already own, cannot take the power company's spent nuclear fuel, take title to it today as the law currently stands?
I agree with you in general. I would note that DOE has taken the position that it has authority under the Atomic Energy Act, under its Research and Development Authority, to take spent fuel to study, and they have done that. The DOE has the core from the 3 Mile Island Unit 2 facility sitting up in Idaho. They studied it. They have occasional assemblies. I believe they have one from North Anna. I think they may have one from Point Beach that has been moved to Idaho and is being studied. The high burn-up fuel program that's being developed already in effect, that's a DOE EPRI program. DOE is going to take fuel, I believe, from North Anna in a cask. Eventually that cask will be moved up to Idaho. They'll open it and confirm that high burn-up fuel is not being destroyed because it's high burn-up fuel. So there are cases where DOE has title, but what we're talking about, those are, very, very small quantities compared to the amounts that we're talking about. And that's not the focus of this project. But I would agree with you that under current legislation, DOE cannot take title to spent nuclear fuel from commercial nuclear power plants, under the current statement of facts. But that could change depending on what Congress does.
Yes, it could change based on what Congress does. But I guess where I was coming was I was going to suggest that this seemed to me like an ideal issue for a legal issue contention. We did not in the pleadings have your position on the lawfulness of DOE's taking title. And we didn't have the staffs, which I think treated that issue as premature.
But the reason we didn't put the legal position in is because it's irrelevant. Because we don't depend on DOE's taking title, and we say we don't depend on DOE's taking title.
But for option one, you do, don't you? Wouldn't you?
If that were the case. But option one, as we've talked about...
So in other words, option one is a contingent option based upon something happening
in the future
that makes it lawful. Okay.
Correct.
So we don't need to argue whether it's lawful today. You agree.
I don't think there's any dispute on the law that, as to DOE's current authority to take title for other than R&D purposes.
Okay. Other than what you characterize, I think, as a narrow research exception.
Correct.
You agree, Holtec International agrees that under the Nuclear Waste Policy Act today, the DOE may not lawfully take title to spent nuclear fuel.
Correct.
Correct. And the staff, I just have to turn to the staff on this, which consider the issue premature. Does the staff agree with that?
Does the staff agree that it's premature, or does the staff agree that it's unlawful?
I'm sorry.
I just want to make sure I'm answering the right question. Are you asking if the staff agrees that it's premature?
No.
Or if the staff agrees that it's unlawful?
No. You've said it's premature.
Okay.
You said it was premature. My question today, having heard Mr. Silberg's statement on behalf of Holtec International, does the staff agree that as of today, it was unlawful under the Nuclear Waste Policy Act for DOE to take title, put aside the research exception, to generally take title to spent nuclear fuel?
The staff has not reached a position on that issue at this time.
All right. Well, we have Holtec's position. We may find that satisfactory. I don't think we probably, we'll probably have a few minutes for everybody at the end if we have time, and we can see. But it seems to me that what I thought appeared to be just a fine legal issue contention is no longer necessary.
I think we're all in violent agreement on this question, except perhaps for the staff.
All right. Well,
But I will note that in the litigation that arose out of the DOE breach of contract, we argued going back to the 1990s that DOE did have authority other than the Nuclear Waste Policy Act to take our spent fuel as they were taking it from foreign research reactors, for instance, or 3 Mile Island. And DOE and the courts, DOE argued that that was a unique Atomic Energy Act R&D authority, and the court generally agreed. We've conceded that since then.
Okay. Thank you. Okay. Well, let me move. I have really just a few more questions, and then maybe we'll take a break after those and go to my technical colleagues. But on Sierra Club Contention 4, this is the challenge to primarily a challenge to the consequences of an accident, a transportation accident, with respect to spent nuclear fuel. The Sierra Club, I believe, relies upon the Lamb and Resnikoff study based on the 2001 Baltimore tunnel fire and treating that as though it had been a nuclear accident and the consequences of that. And the Sierra Club's position is that at the very least that raises a factual dispute for which there should be a hearing. And your position, as I understand it, is that you have cited the 2008 final supplemental environmental impact statement from the Department of Energy on the Yucca Mountain case, which was rather critical of that study and which would be grounds for, I think, at the least, you would argue, at the least saying that is the Lamb and Resnikoff analysis represents a worst case basis, which the applicant's environmental report does not need to deal with. And my question for you, Mr. Silberg, is that apparent from the environmental report? Or I know the commission has said that it is the applicant's job to read, not the applicant's job, the petitioner's job to read the application, read and study the application. But this is a citation in the application. Does the application explain that position explicitly, or would the petitioner be required to read the application and then read every citation in the application?
Well, before we do that, and my colleagues are looking to see exactly what it says, let me make a number of other points.
Okay.
First of all, we don't think that the Lamb-Resnikoff study is material in this case for a number of reasons. One is there's no showing that tunnel is on a rail route that will take fuel from anywhere to CISF. Second, the larger criticism in the Lamb-Resnikoff study is that the fire that engulfed the train in the tunnel was more severe than NRC requirements require. I believe is 1,800 degrees maximum temperature. The NRC Part 71 standards for transportation casks give a maximum temperature number that is below that. I believe it's 1,400 degrees Fahrenheit. So in essence, that's a challenge to the NRC regulations for designing the casks. If they wanted to put in a claim for a waiver of the NRC Part 71 standards, they could have done that. In fact, Part 71 standards should not be involved in this case. The transportation casks that Holtec would use have their certificates of compliance. You don't challenge in this case, in a licensing case for a site-specific license, a certificate of compliance that's been adopted by the Commission in a rulemaking. If they wanted to challenge that, they're well beyond the time frame. The Lamb-Resnikoff study is also inapplicable to this case because the reason that tunnel fire was so intense were the contents of the cars. Holtec will ship spent fuel by dedicated trains. There will be no contents that will be flammable of the type that created that fire in the tunnel. So that study, while it's interesting, and that was a very significant fire, has no relevance to spent fuel transportation. And further, as we explained, there are requirements that the Federal Railway Administration review all the routes to make sure they are appropriate. We believe that if the Baltimore Tunnel were on a transportation route to the high store facility, that the FRA would review that route, and if in their expert judgment they determined that it was an inappropriate route, we would bypass it. If they determined it was an appropriate route and we needed to use it, we would feel free to use it. So for all those reasons, I think Lamb-Resnikoff is of no relevance in this case. It challenges the NRC regulation. Now, I don't know if you guys, I'll pass the mic to Tim Wall.
Yeah. Thank you, Your Honor. With respect to your question about if the environmental impact statement addresses this, Section 4.9.3.2, accident impacts, discusses how the Holtec analysis was tiered off of the Department of Energy final environmental impact statement. So the explicit reference is there. And, you know, while the ER doesn't specifically address the Lamb-Resnikoff report, that's what the analysis is based on. And the DOE analysis specifically addressed the higher estimates provided by Lamb and Resnikoff.
Okay. But Sierra Club's counsel if he read the application and the environmental report, he would have seen the citation, but he would not have been clued in any way that the Lamon-Resnikoff suffered from the deficiencies that the supplemental environmental impact statement addresses.
Certainly, Sierra Club's expert, Dr. Resnikoff, would be intensely familiar with the criticism that's
Good point, sir.
levied against him.
Okay, thank you. But, okay. Couple more questions. Sierra Club Contention 8. And this is a contention that I believe the NRC staff says is admissible, at least in part. The calculation of the annual contribution to a fund for looking for the right word, for closing out the facility, decommissioning the facility. Holtec, I think the staff's principle, I believe Sierra Club saw an inconsistency between the numbers that were in perhaps the environmental report and in other parts of the application. And the staff raised the issue of, well, whether can we assume that every canister is full? They may vary in the amounts. And so from both those directions, there was some challenge to whether there isn't an admissible contention on whether the amount, the metric tons of uranium at a certain amount would give rise to the total decommissioning fund payment that you calculated. What is your response on that?
As explained in our response, Your Honor, they used the wrong number, and so we detailed in our response their contention that when
Excuse me, they would be the Sierra Club.
Yes, Your Honor, Sierra Club. They used the wrong number in their calculation, and we laid out the calculation for them in our response, and also they overlooked the fact of the real rate of return, which was discussed yesterday.
That we understand. The real rate of return they ignored. But there were two numbers in the application, weren't there?
Let me just say, the environmental report clearly says 5,000 metric tons, and you used a capacity of 8,600 and something metric tons times the $840 per metric ton. So that confusion still exists.
I am confirming that the correct number was used in the decommissioning funding plan, but if you give me a moment, I can check.
While Tim is looking, let me make one further point in terms of the staff's, and I don't want to put words in their mouth, but the staff's response to the contention and finding of admissibility was made before it had the benefit of reviewing our response to the contention. I don't know whether the staff would be in a position to say that cleared it up for them or not, but they did not have the benefit of that when they filed their contention responses.
Well, while we're waiting, we might as well ask the staff. Thus far, the staff has not changed its position on anything, but let's ask whether the staff's review of Holtec's response has affected the staff's position. In other words, the simple question, I should try to simplify this, is, does the staff continue to assert that the Sierra Club Contention 8 is admissible, or you would not oppose its admission?
Your Honor, at this point, the staff would like to change its position to take no position on the admissibility of that contention.
The staff is taking note of the position. You're changing your position to no longer oppose? I mean, you're changing your position that you consider the contention now not admissible.
Initially, we had filed saying we found a portion of it admissible.
Correct.
We're changing that to say we're just not responding, or we're not taking a position on that contention.
You're not taking a position one way or the other.
Right.
Okay. Thank you.
Perhaps we can come back to that, or Tim and Kim are both looking for the references.
Okay.
Let me just clarify what I said. It's in the Chapter 1 introduction to the ER, and it says, quote, Holtec is currently requesting authorization to possess and store 500 canisters of spent nuclear fuel containing 5,000 metric tons of uranium. However, if you look at your proposed license, it says 8,680 metric tons. So there seems to be a disjoint between the ER and the proposed license.
Yeah, my understanding is the appropriate number is 8,670 metric tons. I don't know if the 5,000 is still in there.
Well,
the ER.
The 5,000 is consistent with the eventual goal of 100,000.
But
the 8,680 is consistent with the number interveners were saying of, 170,000.
Right, and the assumption is that all canisters are equal, and all canisters are not equal. In fact, the early canisters, which will be Holtec, will have more fuel in them because they have greater capacity than the average of other canisters. So on an average basis, the 173,000 number is wrong because the later canisters are expected to have less fuel than the earlier canisters. I think that's the clarification as to why there are different numbers.
Thank you, Mr. Silberg. I think you're still researching an answer. Is that correct? This could be then maybe a good time to take a little bit of an early break. Yes.
I also have looked at different documents for different numbers about how many metric tons, and I just want to read for Judge Arnold a sentence from page 1-1 of the environmental report. It's in the middle of the page. It says, Holtec is currently requesting authorization to possess and store 500 canisters of SNF containing 8,680 metric tons of uranium, MTUs. So that number, 8,680, appears on the first page of the environmental report. It is revision 3, but I believe it's in earlier revisions as well. Thank you.
Thank you. We have a request here from NAC's counsel. I think we're going to take a break shortly. If you have a minute or two that you can respond, if you wish to respond.
A minute or two, thank you very much.
Okay, go right ahead then.
A lot of their reply regarding, or their answer regarding your question relates to the scope of the ER for an amendment. They say that there'll be an ER for amendment, and our reply is they didn't say that ER would get to facility design alternatives. I want to cite I think you'll find a lot of cases that get to this point. Turkey Point, LBP 90-16, 31 NRC 509, Westlaw didn't give you the page number for this one, 31 NRC 509. The statement says, the scope of a National Environmental Policy Act, NEPA review, is more limited than one performed prior to initial licensing. And it cites the other decisions, LBP 8114, 13 NRC 677. And there's other decisions that get to the fact that an environmental review for an amendment is limited. It's linked to the consequences of that amendment. For an amendment for a cast canister thing, it'd be limited to the cast canister interaction. And that makes sense because when you have a power plant, they get amendments all the time to the license. There's an amendment proceeding. You don't get to go back in that amendment proceeding and redesign and litigate the design of the power plant. In this case, the facility, the ER, is going to govern the whole facility. They said that. So whenever this amendment happens, Amendment 3 gets passed or later amendments to put in NAC, the facility will have been designed and will have been built. So there's no ability to litigate the design alternatives. And then, on the contra side, look at it this way. If we challenge the design alternatives later, we're going to run into this ironclad obligation that is well discussed because we know everything now. We know that They know their design approach. We know it involves the universal cast, which they acknowledged is comprehensive, going to take other canisters. In addition to their point, look at 2.2.2.1 of the ER, which says what universal cast is in more detail. And they're going to know all the information we need at this point to file a contention about the design alternatives analysis. So later on, what are we going to really get out of this that's going to prevent us from running to this ironclad obligation analysis?
All right, thank you, Mr. Desai. Mr. Silver, did you want to say something before we take the break?
I have 2 points. First, I didn't think we were going to get into a debate on individual contentions, but there is again, I would like to respond to NAC Council. The idea that we will have fully designed and built the facility when this issue might come up, we won't have built the facility. Phases, whatever phase we're seeking approval for, won't have been built at the time that change comes forward. And the idea that we have to consider as a design option putting our competitors' facilities on our site makes, frankly, no sense at all. It's as if we wanted to build a reactor with a Westinghouse design, and GE came and said, we want you to evaluate putting a GE plant on that same site. Well, that's not the purpose of this project. As made very clear, the purpose of this project is to deploy Holtec technology. They want to talk about alternative technologies and alternative sites. It's not the competitor.
All right, thank you, Mr. Silver. Let's take a break now. Let's go to promptly at 10:30, and we will resume then. Thank you. Welcome back. Please be seated. They kept it crazy. Mr. Taylor.
Before we move on, may I clarify something that was discussed about the Baltimore tunnel fire and Dr. Resnikoff's report?
Yeah.
Should we be on the record?
You're on the record.
I believe Mr. Silver made some comment before the break that Dr. Resnikoff's report. I don't think that might be on.
Hello? Yes, that works. Definitely works.
Okay. Before the break, Mr. Silberg made a comment, I believe, as I understood it, that the Baltimore fire report by Dr. Resnikoff was not relevant because that was not a route that was being considered for the Yucca Mountain project. It's my understanding that that report was a response to the 1999 Yucca Mountain EIS draft, which did have the Baltimore Tunnel as part of the route to Yucca Mountain, and that in response to Dr. Resnikoff's report, the route was then modified for the final EIS.
Thank you, Mr. Taylor. Back to Holtec. I think you were looking for some information to give us.
Yes, sir. Yes, Your Honor. With respect to the decommissioning cost estimate, Table 9.1.4 of the decommissioning funding plan provides the Holtec estimate for the decommissioning cost for Phase 1, $23.7 million. Section 2.2 of a separate document, the life cycle cost estimate, says we need to collect $840 per MTU to meet those decommissioning costs. You have to use the 8680 MTU number to get to that number. So that's why the decommissioning cost estimates that we provided were based on the intended capacity of Phase 1. And the Rev 3 does have the correct number as far as holding 8680.
Okay, thank you. I think I have one more area for questions myself, and I think there are some questions from some of my colleagues, particularly on the geology issues. My question is on standing. I want to understand Holtec's position on standing a little better. Holtec's position is that none of the 6 petitioners has standing, and NAC is kind of a different case, but I don't know, Beyond Nuclear has a member who lives a mile, I believe, from the facility, and I'm not quite sure I fully understand Holtec's position on standing. I guess my concern, to give it to you, is that is Holtec arguably conflating the test for an admissible contention with the test for standing? I know the Commission tells us that when we consider standing, unlike when we consider contentions, we should be fairly lenient in finding standing. And if someone lives a mile from a facility, do they have to establish a pathway, a possible leak from the facility? If you're putting all these metric tons of uranium practically in their backyard, doesn't that give them standing? Would you like to explain a little more why even those who reside very close to the proposed facility, in your view, do not have standing?
Thank you, Your Honor. Yes. Our position is that the Commission requires a case-by-case analysis of standing and materials license cases, and specifically, it is the petitioner's burden to show that they would be impacted by the facility, and in this case, they have not done so. There are several reasons for our position. It is true that petitioners are obligated to demonstrate some sort of plausible mechanism by which they would be impacted by the analysis, and there's Commission case law on that. In particular, the U.S. Army Installation Command case, which is a case cited by several of the petitioners, where the Commission, rejected standing, where it found that there was no obvious potential for off-site migration of the radionuclides in that case. The Commission has also issued some rulings with respect to, what type of dose has to be received in order to constitute a harm. And their Energy Solutions case in CLI 11-3 says mere potential exposure to minute doses of radiation within regulatory limits does not constitute a distinct and palpable harm on which standing can be founded. The SAR, Table 7.3 of the SAR, gives you the dose at 1,000 meters or a kilometer away, and that is 0.0848 millirem. And no one has asserted that they reside closer to that there. And that's assuming continual 8,000 and change hours of occupation. It's a 24/7, 365-day-a-year analysis. There's been some discussion, too, about some of the case law in here, in particular the 17-mile radius that was established in the Diablo Canyon and the Sheeran-Harris cases. Those cases are easily distinguishable from the one present here. Sheeran-Harris involved a spent fuel pool expansion proceeding, and in that case, the activities that were going to be licensed involved actual handling of bare fuel, having it shipped in transportation casks, unloaded and put into the spent fuel pool at the Harris plant site. In the Diablo Canyon proceeding, while yes, that was an at-reactor independent spent fuel storage installation, the licensed action there involved, first and foremost, an above-ground independent spent fuel installation, whereas the one that we propose to build will be below ground and therefore has a significantly different risk profile. But in addition, the licensing action, Diablo Canyon, involved the placement of spent fuel from the spent fuel pool in the canisters and then moving those canisters onto the pad. Those operations are not present here in this proceeding. The canisters, as my colleague said in the very beginning, are going to come to the site sealed and will not be opened. And so our contention is that petitioners have not demonstrated that that case ought to apply here. And again, I think it's incumbent upon the petitioners to show in a case-by-case scenario why that ought to apply here, and we don't think it does.
Okay. I guess the problem I potentially have with that position is that I have a hard time imagining who would have standing in your view. You say that the canisters are not going to leak, the casks aren't going to leak, but can you tell me who might have standing? Can you think of anyone who would possibly have standing under your theory?
Your Honor, it's petitioner's burden to demonstrate they have standing. We've laid out all the facts that are appropriate here.
Okay. Thank you. All right. I think, Judge Koukouros, did you have some questions?
Yes. Unfortunately, many of my questions have already been answered, which is convenient. We started a discussion yesterday with the Don't Waste Michigan group regarding their contentions 5 and 12. And I had asked the question, would subsidence on the site potentially cause damage to the UMEX storage system? And the answer, of course, came back yes. I will ask you the same question, and I'll add to it that if you tell me that the design of the system incorporates subsidence as part of the design basis, then perhaps the answer to that question is no, but what is the correct answer?
The correct answer, what we believe, is that there won't be subsidence on the site, and we've provided information in the environmental report, which also refers to the ELEA 2007 report, which underwent a detailed analysis of the site itself, looking for evidence of subsidence, and this is specifically the site, not West Texas, which interveners or petitioners have used as their basis for subsidence. They refer to West Texas. We're looking at the actual site itself, and it goes back about 50 years worth of what they're looking at, and there has been no evidence of subsidence at the site that we have seen.
So you're saying there won't be subsidence, and you don't have to account for it for that reason? Okay.
We believe that it's not a credible threat.
It seems like the SAR, I think, agrees with you on I think it's page 2-54. I mentioned it yesterday. Seems to indicate the same as what you're saying. However, the ER does have places where it seems to indicate that subsidence is possible. Page 344 to 345, again, that's a PDF reference. It's the section that says Pecos Valley section and physiographic subregions. It says solution subsidence depressions of varying sizes are common landscape features across this section because of the dissolution of evaporating carbonate units.
I'm sorry. Q 344 and 345 of the document that I'm looking at appear to be graphs.
Well, that's okay. So this is a PDF document, and the one I have is obviously different than the one you have. The section is called Pecos Valley section and physiographic subregions. That's the section name.
Is it possible that you're looking at Rev 3 of the document?
No, I'm not.
Well, in the area there has been subsidence in the general Permian Basin region. Without looking at the document itself and finding the page, and I might have to get back to you a little bit later, I can't tell you specifically if this is near the Holtec site. We haven't seen subsidence near the Holtec site. However, in the overall Permian Basin region, there has been some. It's typically more associated with the potash mining that occurs in the area, which is why in section 3-2 of page 3-2 of the ER, we referenced that Holtec holds the mineral rights for potash mining down to 5,000 feet, which is why they don't expect subsidence. Once you get below that level, you don't expect subsidence to occur, and in fact, the Schaefersman report itself indicates that activity below 3,000 feet would not result in subsidence. He says that on page 15.
All right. And I bring this up because, of course, it's Stone Waste Michigan, two contentions specifically deal with this. We learned yesterday from Mr. Lodge that there's an RAI that was issued recently, well, I guess it was March, that dealt with this, and we haven't, I hadn't seen the RAI or any answers, so this was all news to me, but the subsidence, it would be a common mode failure in risk parlance. It wouldn't potentially fail one canister, it would fail all canisters, all casks, perhaps I should say. So it's a serious matter and not one that should be lightly dismissed.
Your Honor, the RAI in question, Your Honor, the RAI in question was issued in March of 2018 of last year. It was responded to in May of 2018. The interveners or the petitioners had the opportunity to address that RAI in their contention if they so choose, and they did not. We can probably provide an ML number for you with a bit of looking. In terms of the risk of subsidence, again, we do not believe that a risk has been substantiated at the site. We do not believe the petitioners have put forth a risk. And given that Holtec controls the mining rights down to 5,000 feet and that there has been no evidence of past subsidence, we don't consider this a risk that is credible.
Okay. But the petitioner did put forth a challenge to that in contention 5 and 12, right? Correct? And they do have an expert who supports their position.
The petitioner's own expert indicates that there is no risk if the drilling occurs below 3,000 feet, and we own the mineral rights down to 5,000 feet.
With respect to hydraulic fracturing,
we own the potash mineral rights down to 5,000 feet. Potash mining occurs above 5,000 feet, traditionally in the 1,000, 2,000 range. As petitioners even note in their own report, oil and gas drilling occurs much lower, generally 8,000 feet.
And what about contention 12 with respect to the geology below the site? Their expert, Dr. or Mr. Schaffersman, I believe it is, indicates that the nature of the geology of the site is significantly different than what's mentioned in the ER. I think I mentioned this yesterday, but comparing Section 3.3.3 of the ER with Section 2 of the, I guess I would refer to it as the Schaffersman report, are in direct contradiction with respect to the occurrence of karst in the geology of the site. And my understanding is that the karst geology does lead potentially to subsidence. And also, subsidence has been shown to occur in the vicinity of the site. Now, you're saying it has not occurred at that exact spot.
And there's a lot of data to support that assertion. I don't read the Schaffersman report as asserting that there is karst specifically at the location. In fact, I believe he says that there is not. What he does point out is that there is a salado area below the site. I believe he says that it starts at 1,400 feet. And he alleges that the salado area may grow into karst if there were leaking oil field waters, old brine injection wells, or broken casing, causing a dissolution cavity to develop in the salado. I don't see any specific references to particular karst formations at the site itself. However, I would say that these are all speculative. He's assuming that a series of events may occur that have not occurred at the site. And all of this, again, is contrary to the evidence at the site, but there has been no substance there. I don't see anything in the Schaefersman report that specifically points towards karst at this specific site. He does say, of course, that it's in West Texas, and it's in other areas of the Permian Basin, which we do not dispute. I will make a note that the basic geologic data on page 13 of the Schaefersman report, to the extent that you're relying on it, this is geologic data for well CP975. That is not at the Holtec site. That's actually at the border with Texas. It's somewhat unclear from the report where that's located.
Yeah, I'm not relying on it. The petitioners are relying on it. Okay, well, I understand. But we do have a contention. We have two contentions that deal with this, and they are supported by expert opinion.
Well, we disagree that the Schaefersman report supports the existence of karst at the site or subsidence at the site.
But right now, we're not in a hearing.
Well, it's the petitioner's own documents can be reviewed to whether or not they support the contention. In fact, the petitioner's documents that are put forth in support of a contention should be reviewed to determine whether or not it prevents an adequate basis for factual or expert support.
Okay, that's fine. At this point, that's enough. But I will, again, remind you that we were told yesterday that the staff is looking at this as well.
Just as one last comment, again, that RAI was from last year and it has been responded to. We can get you the ML number if you wish.
Yes, I hope,
we'll look for
hope
that.
you can, yeah. All right. Okay, I'm going to jump around a little bit at this point and ask.
If it's geology, it's still me.
No. It's. I have other questions. How do you want to do this?
Did you have questions? Further questions?
Not on this.
Yeah. Why don't you continue?
Okay. All right. I'm just going to try and fill in gaps that I have. With respect to the start clean, stay clean question, if a canister doesn't meet the receipt and inspection procedures that Holtec has, the plan is to ship it back to the sender. Would there be, and of course it would have to meet the requirements of 10 CFR Part 71. If it doesn't, if it can't be shipped back, and I assume that may happen, there's no indication that it couldn't happen, what would happen at that point?
Your Honor, we don't anticipate it happening at all. If a canister is found to be leaking or damaged in any way, it will be shipped back in an NRC-approved transport cask, and it must be shipped in accordance with Part 71. And we can't imagine a circumstance where a canister that doesn't meet our requirements would not be sufficient, when inserted into the transportation cask, would not be sufficiently protective. But we would take whatever steps are necessary to ensure that it could be transported back to its originating site.
Yeah, do you have the ability to, for let's say canning or anything like that at the Holtec facility?
No, we do not.
I
I will make one further point. That is, you can insert a Holtec canister into a sleeve if there's a problem with the canister before it's put into the vertical shaft. The shaft has enough clearance to support an additional canister over the canister before it's permanently or temporarily set in the vertical shaft.
Okay.
Your Honor, I don't know if an objection is appropriate, but this is the first time I'm hearing this information.
Excuse me, Mr. Lodge. You might ask for the opportunity to speak.
I'm sorry, my apologies. I may be heard for a moment.
Yes.
Thank you. This is the first time we're hearing this information. We're trying this case, we're trying things on the merits, so it seems. Certainly there is a problem of conflating standing and merits kinds of issues I've been hearing this morning, but this is new information and a representation of counsel. Certainly nothing we've seen in the documentation. That there's some sort of mitigating methodology that's available if there is a troubled canister that is delivered to the site.
Is that your point?
Yes.
Okay, thank you.
Your Honor, we have an ML number available for you for that RAI response, if you're ready. This was RAI 2-2, and the ML number is ML 18150A330.
That was ML 18150A30?
A330.
A330. Good. Okay, thank you.
Thank you.
Okay. In your answer to contention 23, you state the system allows for ready retrieval of the spent fuel from the storage system for further processing or disposal. Can you tell me what you mean by further processing or disposal?
Your Honor, that simply means removing it from the storage module and sending it to a repository, as is the hope one day. Taking the canister out of the module and sending it to its ultimate disposition.
Regardless of its condition?
It's supposed to meet the staff's interim staff guidance too on retrievability. That's why we state that in there. In prior to transportation, the canister will have to be inspected again to meet the requirements of Part 71.
All right, so what you mean is shipping it off-site to a disposal facility.
Correct.
That's what that means. Okay. That's fine.
Thank you for calling the conference center. At any time during this message, please enter your passcode followed by the pound sign. If you are a participant, you may hear music until the leader activates the conference. Thank you for calling the conference center. Your passcode has been confirmed. You will be joined in listen-only mode.
Which means, of course, it could be 68.2. So how do you reconcile? And this Appendix B is the references given for what should be acceptable to your site for an MP37. There's also an the MTC 89 portion of that It's very similar, but it's 65 gigawatt days per metric ton, so it's slightly less. So you have a design basis assembly of 45, and you have assemblies coming in that are, let's say, 65 or perhaps more gigawatt days. How does that all work?
Just to confirm, you referenced table 5.0.1 from the UMAX FSAR, and
yes.
You mentioned also a table 7.1.1. Is that in the same document?
I believe so, yes. In fact, it is.
That might be the high storm store.
I believe it's identified as the UMAX FSAR.
We don't have a table 7.1.1 in the UMAX FSAR.
We recommend that we take a moment.
Let me take that back. The first table is the UMAX FSAR. The second table is the CISF. Yes, that's correct. FSAR.
Can we take a moment to research and get back to you?
Sure.
Yeah, we can either do that over the lunch break and continue now, or take the break now in place. And
it might be better to do that, to give you the time to do that, and unless it's going to be very quick.
Yeah. So, I mean, do you want to continue with your other questions now, Judge?
I think we have the answer.
Okay, good. Excellent.
The answer is that source terms and doses are based on a combination of burnup, enrichment, and cooling time. The chosen mix is reasonably bounding. Burnup alone does not determine dose for the spent fuel.
Okay, but it is a factor.
Yes, it is.
It's not all, but it is a factor.
Yes. But the certification for the UMAX system is up to, is capable of storing the MPC canisters. That is specifically stated in the certification for the UMAX.
All right. So, in other words, that 65 or 69, depending on which canister it is, can be accommodated safely. And the fact that the UMAX table 5.01 calls that a design basis assembly of 45 is not what goes into the analyses. The analyses are done to accommodate the higher burnup, the highest burnup you can accommodate, which apparently is 65 for the MPC.
Hold on 1 second, Your Honor.
We'll come back to this, Your Honor.
Okay. All right. That's fine. Your ability to retrieve canisters under all conditions of storage, those are, I believe those are your words. They're referenced by the staff at various times, and we just talked about that. Your environmental your on-site radiation protection program is capable of accommodating any condition of a canister when it's retrieved for disposal. Is that correct?
Yes.
That's correct.
Yes.
So no matter what cracking you might see, no matter how much failed fuel there may be in a canister, you can retrieve it safely and send it off for disposal.
I assume that there's a credibility issue here. One can postulate the meteorite hitting the cask dead on.
Yeah, let me correct that. I'm talking about all normal conditions of storage over a long period of time.
Correct. That's correct.
Because we do have a service life issue of, or a defined service life of 100 years, or
yes.
perhaps even more. I don't remember. All right, thank you. If a leak occurs in a canister while it's in the UMAX enclosure, can it be identified?
We would expect, we wouldn't expect any leaks, but the aging management program is specifically in the application to deal with those kinds of circumstances.
Okay. And, I do believe from what I've seen that you would lift the canister out of the enclosure and inspect it as you bring it out at various levels to see if there's any cracking. Is that correct?
The monitoring would be visual. There's an annulus between the canister and the cask wall, and the monitoring would be done visually, remotely visually.
Right.
We're not sending people down there, but we'll send equipment down there.
Right. So you'd be lifting the canister out and visually inspecting the
Well,
canister.
I think you might visually inspect it before you lift it out.
So you could send a camera down and visually inspect it. Okay. Can a leaking canister be repaired?
The answer is that it's outside the scope because there are no credible leak paths.
Okay, I take that as a no.
At the present time, it's not within the scope of this license application.
Hypothetically, if a leak did occur, could you put it inside another container?
That's what we talked about before, where you have the encapsulation and the vertical casks have enough clearing to insert an over canister over the canister and inside the vertical module.
So any assertion that you had no way to handle a leaking canister is incorrect?
That's right. The question was, can you repair a cask? And that's really outside the scope. But that's not to say that you can't take steps to remedy a problem, even if something happens that we don't consider credible, which is a leak through the cask.
Right. Can you remove the fuel from a cracked canister and put it in another canister?
If you have the right facility, yes. But that's not part of the design of high store.
Okay. Well, I think you've answered my next question. Have you seen any cracks in canisters in the past? And sounds like you said no.
No, there have been none. The question about removing fuel is the dry transfer storage discussion that we had yesterday. It is a technique that is possible. It is not part of the design. The design would have to go through a licensing process. That's stated very clearly in the continued storage rule that adding a DTS would be a licensing event.
Okay. I guess the problems of saying a no-free, are they applicable here? I'm not very familiar with the problems.
Yeah, the answer is we believe no. The standoff pins are no longer being used in current manufacture. There are all, I think, 42 casks that have those. The problems in San Onofre, we do not think are relevant at this site. Okay.
The aging management program, not specifically the high burnup fuel one, but the standard aging management program, does include testing of groundwater. And can you tell me what that means? Because we have an outstanding contention that claims that there's groundwater that you have not, that you don't know is there, so to speak.
Well, we have existing wells that have been monitored that have identified groundwater. The results of that are set forth in the application. I don't know off the top of my head what the aging management plan says on that specific topic. We can certainly find that information and get it to you.
Yeah, it didn't have a lot of details. It basically said you would be testing the groundwater. It didn't identify, I don't think it identified specific wells or anything like that. I don't even think it identified the groundwater specifically, if it was talking about aquifers or, but again, you know, we've been through so much material, I can't remember the details of that. But if there were near surface groundwater, do you believe that the aging management program would capture that?
We do.
Okay, and in terms of cracking of the concrete support plate, the bottom concrete support plate, if there were a crack in that, water would get into the annulus between the canister and the UMAX enclosure wall. Do you monitor that for moisture?
Well, first of all, my understanding, and to be directed by our technical experts, is that groundwater is not at the level of the bottom of the vertical canister. I don't know how far below it is. Okay, we don't have the number, but it is not at the level or above the level. So, A, there is no mechanism for getting water. B, there is no mechanism for concrete cracking. Whether or not we monitor the bottom of the annulus or the bottom of the vault for water, we don't currently monitor that.
You don't monitor?
No.
But you can put a camera down there to look at the canister wall, so therefore if you saw water, I assume you would take action.
We would indeed.
Okay.
And to our knowledge, those kinds of requirements are not imposed on the current in operation UMAX systems at U.S. plants.
Okay. With respect to the question of brine being in groundwater, I believe that your aging management program, groundwater testing, does include brine testing. Is that correct?
Yes, that is correct.
If there were a crack in a spent fuel storage canister, and I understand there's never been one and you don't anticipate one, would that result in a release of radioactive material, or would there be a need for further fuel damage internal to the canister for a serious release?
To the extent that there's been allegations of a release that's liquid-based, we don't believe there's any mechanism for there to be such a release, given that there is no liquid stored at the facility. In terms of I'm not sure, in terms of dose, is that the other question?
Well, so if there were moisture in the annular region and it caused corrosion of the canister and the canister cracked, there would be no liquid release. There would only be fission product gas release, correct?
That's correct. There are no liquids.
We have a contention that talks about the near surface groundwater. Do you have anything more to add on that regarding the presence of near surface groundwater?
In terms of near surface groundwater, we believe that the only groundwater that has been located was in well ELEA 2, I think is the number. And it was first identified at a depth of 90 to 100 feet, and of course it welled up to about 35 feet, I want to say. But the other wells that were drilled, including in the GEI report, did not encounter any groundwater at those levels. They were looking for groundwater as they went down. As we detail in our response, they took spoon samples, but there was no other groundwater at a near surface level that was identified at the facility.
Okay. And I think your answer to that contention, I think it's contention 15, Sierra Club contention 15,
yes,
supports
we detail that. Yeah.
Yes. Okay. There was a discussion yesterday regarding hypothetical accident conditions versus real-life accident conditions. Can you address that with respect to what you've done for your for your canister and cast design? Do you do any kind of computer code about analyses? Is that part of your design basis?
Well, certainly computer code analyses are part of that basis.
Okay. That would be hypothetical accident.
For transportation casks, we have done physical tests, yes.
Okay. So for what were termed hypothetical accident conditions, you do computer code analyses. For real-life accident conditions, you put these canisters and casks through physical testing requirements as required by the regulation.
That's correct. Okay. And there are many tests that have been done on canisters, casks over the years. That data is certainly included in the way that these new casks are analyzed. We don't necessarily test to failure every cask design, but there have been those tests in the past, and the results of those tests are certainly incorporated in how casks are designed.
The thermal analyses that you do to assure that you don't exceed the I'll say the high burn of fuel temperature limits, but I mean it for both high burn up and non-high burn up fuel. Those analyses, are they computer code analyses, or do you do any actual testing?
Computer analyses.
Okay. Do you do any kind of data capture when they're in the enclosure to make sure that your computer code is correct?
We have benchmarked in the context of the UMax design. There have been benchmarking tests that are done.
Okay, so you have experimental data that you correlate your computer codes against?
Yes. Okay. I apologize for turning around, but I don't like to give those technical answers based on my technical.
Please, I'm happy to have you turn around as much as you need to. The contention, Sierra Club Contention 21. That's dealing with this question of transportation of high burner fuel, and that it would be dealt with on a case-by-case basis. Can you say anything regarding that as it applies to your storage facility?
Well, as I understand it, the certificates of compliance for UMax, for the transportation cask, and for the canister all include high burn-up fuel. So to that extent, they are currently licensed. They've been approved by the NRC, obviously. And at the present time, there's no more that is required. We have met the NRC's tests. We have met the regulatory criteria.
Okay. You also answered earlier that all of the new research that's going on, that you're plugged into that research, and that you would be required to make changes as indicated by that data?
As necessary. The Aging Management Program will incorporate the results of the DOE EPRI program on high burn-up fuel. Those results will be incorporated as appropriate.
You don't have your own demonstration program for high burn-up fuel?
No. Okay. I think the DOE EPRI program is intended to be an industry-wide program with wide participation by the utility vendor community. DOE and EPRI, I believe the NRC is an observer to that program, or perhaps even a participant in it. Certainly they're aware in detail of what's going on.
All right. The interim staff guidance seemed to imply that they had a fairly active role in it, because I think that's part of the case-by-case basis discussion. But
that's right.
A number of these questions are going to have to be asked again. What about transportation within the facility? In terms of Contention 21, is that...
Well, generally, I don't know in this particular case, but transportation within a facility, a Part 50 facility, where you're moving casks from the reactor building out to the ISSC, those don't require Part 71 approvals. My understanding, they're all done under the Part 72 license. The transportation down the haul road using the vertical crawlers as appropriate are reviewed by the NRC, but I don't believe that it's part of a Part 71 program, if that's what the question is.
Yeah, that was the question. Part 71 does not apply.
Correct, until you go off-site.
Yeah, correct. Okay. I think I'm okay for now. Thank you very much.
Judge Arnold?
I do have some questions, and I'll be asking some questions similar to Judge Trikouris, but too difficult to filter them out. Having to do with Sierra Club contention number 2, the issue of safer and more secure. Do you explain in the environmental report what you mean by that?
Yes, we do. We explain why we believe, although at-reactor storage is safe, it's been designated by the NRC as safe, that on an overall basis, the high storage facility will be safer and more secure. It's more secure because it's remote. It's safer because it's underground, among other reasons.
Did you intend for that statement to be inclusive of the transportation of fuel, or just once it's at your facility?
No, it includes transportation, and for that we rely on the generic analyses that say transportation of spent fuel is a minor environmental impact.
Concerning Sierra Club contention 4, having to do with transportation from the reactors to the CIS. Now, they fault your dependence on New Reg 1714, saying it is only for the regional transportation, not across the whole country. You state in your report.
Is 1714, is that the PFS EIS? I believe it is. But.
See, and this was in Toole County?
Yes, that's PFS. Tooele.
Toole, okay.
Close enough.
What exactly, now, in your response, you said that looked at more than just the region.
Yes, my recollection is that contention said that EIS only dealt with local transportation, and that's incorrect.
Okay. Now, in this contention, petitioners appear to have a credible analysis of the radiological consequence of a transportation accident occurred while shipping spent fuel. On page 25 of their petition, they compare the results of that analysis to the results of your analysis and find their results to be orders of magnitude, 1,250 times the result that you have. Now, how can we not consider that a material dispute of fact with the application?
We believe you have to look at the document that they rely on to determine whether it is material to this proceeding. And we've had some discussions about why we respectfully submit that it is not. If they submit a material document, even though by a PhD, even though it looks like a credible report, and it may be a credible report, if it's not material to this case, it can't support the admission of a contention.
Concerning this analysis, I think it was yesterday you said, or maybe it was today, the temperature in that tunnel was greater than the temperature required for the certification of the cask, correct?
That's my recollection, yes.
And you said that somehow using that fire would be a challenge to the rules?
Using the temperature of that fire to say that our transportation is inadequately analyzed is a challenge to the rule. Also, the conditions, as we discussed earlier, of that fire are not relevant for the reasons we discussed.
Okay. I'm more familiar with the reactor world than spent fuel, but in the reactor world, it's been demonstrated several times now that actual accidents sometimes do exceed the design accidents. And So it seems to me we've got a historical fact that a fire on a railroad in a tunnel can exceed the design temperature. Does acknowledging historical fact constitute a challenge to a design specification?
Yes, and you have to also look to see whether that event is relevant, as we described earlier. The magnitude of that fire was a result of the combustibles. The combustibles in that tunnel on that day are not what you would have with the transportation of spent fuel. Whether the design is sometimes exceeded in real life, we nevertheless have an NRC regulation. If the petitioners thought that that regulation was inadequate, they should have sought a waiver under the Commission's procedures. They did not do that. This is not new information. They've known about the Resnikoff analysis. They've known about the Baltimore tunnel fire. If they wanted to challenge the applicability of the regulation in this case, they had more than enough time to do so.
Concerning petitioners' claim that the railroad infrastructure is deteriorating, when it comes time to move spent fuel, will you be permitted to make use of any railroad track that is in place and available? Or is there some inspection? Do they look to see if the tracks have recently been certified? Or
as we discussed in our response, the Federal Railway Administration does that function for transportation routes over the rail. This will not be the first rail transportation of spent nuclear fuel in this country. Those procedures have been in place. They've been exercised. We've had perhaps hundreds of shipments over the rail of spent nuclear fuel in this country. We've had thousands of shipments over the road in this country. Worldwide, it's even greater. But yes, the rail infrastructure for a particular route will be inspected at the time a route is chosen and the time the shipments will take place.
Okay. So a railroad track that is today in excellent condition, but is in the future, deteriorated, that could be okay for shipment now, but not okay when you go to the Part 71 shipping process, and it would be precluded from use?
And vice versa.
Yes. So now is not a good time to be determining the condition of railroad tracks for future use.
Now would be a very bad time to do that. In this context.
Sierra Club Contention 9, the ER must examine the environmental impacts of the containers being used beyond their approved service life. Do you anticipate there will be any time where you have spent fuel stored in a container whose certification has expired?
No, because we would apply to extend that certification, at which point it would be reviewed by the Nuclear Regulatory Commission.
And you have a system in place that will assure that's done?
We are obligated to meet our license conditions. One is when a license expired, we will file in advance because we want to take advantage of the timely renewal doctrine. Also, this brings into play the continued storage rule because we do not have to look at environmental impacts beyond the license life.
Concerning Sierra Club Contention 11, concerning the potential consequences of an earthquake, does historic data account for the possibility that recent and future oil and gas drilling may affect earthquake frequency or severity?
We believe that it does. There's been drilling in the area, as is mentioned in the expert report, used by petitioners for over 40 years, I think over 50 years. There's no reason to believe that the current historic data does not encompass drilling. In fact, the expert report put forth by petitioners does not have any more recent earthquakes than the 2012 earthquake that we already analyzed for. In addition, we believe that the report put forth by petitioners does not support that there will be more earthquakes in that region going forward. If you read it in a great level of detail, it actually finds a low slip fault potential in the area of the Holtec site. So we don't believe it even supports their assertion.
Does it support any increase in the severity, ground motion of earthquakes?
No.
You have some sort of design ground motion?
Yes. In fact, there's the design ground motion for the high storm facility, which is, I believe, between 0.7 G and 1 G, depending on the acceleration and the orientation of the ground motion. The bounding analysis for the site has been referred to as 0.25 in every direction. That is far greater than what the USGS returns for the site, which is only 0.04 to 0.06 G. So that the UMAX high storm design well bounds any potential impacts from the site.
Okay. So you're saying the design ground motion is not a close fit to historical data, but is, in fact, has some margin?
It's significantly larger.
Okay.
I'd like to be able to get done before lunch.
You want to start lunch now?
Judge Arnold and I have agreed that this might be a good time for lunch. We're obviously not going to finish this morning. I'm very optimistic we will finish today. So we'll take an early lunch again, I think, because there's no cafeteria in this building. People have to go out for lunch. We'll take about an hour and a half. So why don't we plan to reconvene promptly at 1:15? Thank you.